In my own state, for example, in Michigan, and I understand in your state in Illinois, one has been submitted for approval. It was a personal privilege of mine to sit on a 21-man task force in Michigan to develop our plan. We had a total of 8 members from labor on that 21-man task force. When you take away the impartial chairman, there's no way in the world those 8 persons from labor could have ever carried the vote. It would always have been 12-8. It was an uphill battle to establish some good, sound principles that we thought, as a task force, that should be in the plan. But I submit to you today, not all of those principles were adhered to. We think there's some serious gaps. Again, UAW has made this known to the new secretary, the assistant secretary, Mr. Brennan, no less than twice, that we think not just because there are over 600,000 UAW members in Michigan, but Michigan is a very highly industrialized state. There are a number of workers in that state that are going to be affected by the Michigan plan when and if it is approved. Therefore, we think, in deference to those workers, that each and every worker, each and every union that represents workers in that state, rather, as well as any other interested parties, persons, or groups, should have their day in court, and we have asked, in their discretion, rather asked that the discretion of the assistant secretary notwithstanding that we have public hearings. As yet, I don't know. Personally, I doubt it. Following our policy and following the seminars and the conferences and the training sessions that I spoke of, there have been some good case feedback. By this I mean persons who've been in attendance at those training sessions, those conferences, those seminars. They have sent to us copies of citations, case histories of things that are taking place in their plant. And I'll just share a couple with you. I think that you know that we have a case out in Philadelphia with the Bud Company that involves the question of whether provided as used in 1910.133A relative to protective devices, if that provided means at the cost of the employer, essentially that. We were able to convince a hearing judge that it should. That is, the Bud Company should pay for the safety shoes that the compliance officer said should be worn in a certain occupation. The company, of course, takes the opposite view. They were successful in petitioning for a discretionary hearing before the commission, and to my knowledge, it's still there. Is that right, Frank? It's still there. Now, this will have landmark importance to all of labor. No matter what labor union you may be affiliated with, especially if your members will have to rely upon the decision as to whether or not an employer should pay for protective devices, and in this particular instance, safety shoes. To the extent that we have a very capable law firm out in Philadelphia who's done some fantastic brief work in this, I've read a couple of them, that our own legal department is prepared to go with this one all the way. I guess this is somewhat comparable to the case that the oil chemical workers started some years back relative to the walk-around pay. We're just as adamant. Finally, I'd like to share with you, in addition to the survey and some of the case feedbacks that we've had, occupational safety and health in the coming set of negotiations. Now, this is the banner year for negotiations 1973. Now, perhaps you may not know this, but we really negotiate the year round, 12 months out of the year, every year, because a number of our independent plants, they're not tied in with Big Three where they phase out at the same time. So in addition to our guys in the various regions around the country who will be negotiating for Big Three, they also will be carrying on their daily and their monthly negotiations with other smaller plants. But in our Big Three plants, with the exception of Ford Motor Company, we do not have occupational safety and health language per se, that is, in express terms. We have that right to strike, and we've used it. And one of the positions, of course, is that that right to strike shall remain inviolate. Where we have it, we're going to keep it, and where we don't have it, we're going for it. But as you've read in the papers, that one of the things that we'll be talking about very seriously will be the Joint Occupational Safety and Health Labor Management Committees, because we want to see the involvement all the way down the line. That sits right along with UAW policy, whereby we have the local union safety representative at every local unit, at every unit. If there's an amalgamated local union, every unit within that local union has the right to have a local union safety representative, and in some instances a or an alternate to cover the off-shift situations. So we're saying here, with the involvement of the Joint Occupational Safety and Health Committees, again, we will have participation right where it should be, where these persons can see for themselves what's going on the job, so that when a compliance officer comes in to make an inspection, whether it's a routine inspection or whether he's called in, then these persons have a working knowledge, because it is that person, the person whom you authorize as the employee representative to walk around with the compliance officer, who should be equipped, knowledgeable of the goings-on in his particular area, so that he may call them to the attention of the compliance officer. Obviously, management's not going to do that. So this is the kind of thing that we're thinking about. I mentioned the language in Ford Motor Company. They have a very good setup presently, whereby any occupational safety and health problem, instead of going the routine grievance procedure, they have a separate setup, including the right to strike. There will be no tampering with that. And if anything, we'll seek to improve upon it. But as you may or may not know, in 68% of our collective bargaining agreements, and this figure was tabulated in 1969, we do have real occupational safety and health provisions, both in terms of the protection as well as the protection equipment and devices. In the last round of negotiations, we made some real inroads in one of our Ag-Imp contracts, namely John Deere, whereby we not only have the recognition of such a committees, but training time as well. In addition, there has been some talk about what do you do when there's a situation facing a workman on the job now. Some contracts we have the right to call in the safety and health representative to get an evaluation of that particular operation, and if it's deemed or it's questionable, its safety, the person might be moved to another job without any loss in pay. Many contracts we don't have it. That's something else that we'll be talking about. We'll be talking about the right to red tag, this committee that I spoke of. The right to red tag such an operation. Or maybe we may have a setup whereby, in the alternative, a qualified occupational safety and health consultant may be available that we may go to for some immediate relief. So these are the things that, not in its entirety, of course, but just some of the things that you've heard about and some that you will be hearing about as the year progresses in negotiations. So with that, then, I think I should close, and I'll be available for any questions that you might have. Look forward to a nice session.